Hi folks, how are you? My name is Phil Weiss. I founded this group along with Warren Allen and John Randall about a year ago today. It's appropriate we're talking about user-generated content tonight because our first meetup, almost a year ago today, was about mobile privacy, and I think the two issues are clearly very related. It's also appropriate because we founded this group about a year ago in response to the SOPA-PIPA controversy, partly out of frustration with the disconnect between the governors and the governed, and to kind of generate discussion among all the stakeholders in a particular issue to come up with new methods to address common legal issues. Since then, we've been holding monthly meetups that address issues at the intersection of technology and law, and to come up with methods, whether they be legal or extra-legal, not illegal, extra-legal, that potentially deal with those issues. So before we get started with the panel tonight, and we have an awesome panel here tonight, and we're going to have a great discussion, I would like to make an announcement. First of all, that we are coming up on our anniversary, as I said, and as far as I can tell, with a quick survey of Meetup.com, we are the largest legal meetup out there. We're at 450 members, which it's kind of overwhelming for us. It takes a lot to put these events together. But we enjoy putting them together very much, and we look forward to growing even more over the next year. That said, we have, to kind of help our growth along, appointed a set of board members, and we've also launched a site. Semi-launched a site, it's not quite launched, but we are building a site outside of Meetup.com, sorry Dave. And tonight I'd like to announce our board members. Warren Allen, the director of Hayden. Tarek, the director of Lost Chicago Hope. That was relevant a few weeks ago when the Bulls lost. Lauren, the director of Awesome, and myself, I'll save myself for last, the director of Procrastination. And of course I'd like to give a huge thank you to our new advisory board. Veronica from Docracy, Dave from Meetup, Jonathan Askin from Berkeley Law School, Jorge from Silas Capital, and Eric Adler from Adler Vermillion. We're so pleased to see these people on our board and so interested and involved in our group, and we look forward to working with them in the future. That said, let's get this event started.
Thank you everyone for coming, and thank you to our awesome panelists. I feel totally terrified to be in front of you all and be asking you questions, and hopefully I don't embarrass myself too much. So I'm just going to introduce everyone, and again, thank you all so much for coming. And Eugene right now, ironically enough, is taking a picture of me, which he's going to put a hashtag on, which is something like awkward legal hacker photo. And so I think that's actually very relevant to the discussion we're about to have in how people's content is uploaded, how it's uploaded not necessarily with their consent, and how it can come back to bite them down the line. So we wanted to do this topic for the longest time. It interests almost all of us who are involved in founding this group. It's an issue that we all sort of grew up with as people who, children to some degree of the download era, which, we didn't necessarily have quite the civil rights movement. We didn't see some of the great cases of the civil rights era, but the legal battles that we saw were actually played out with respect to technology and emerging kinds of technology and what people wanted to do with that technology and the rights associated with it. So from that perspective, this is something that we've always had in our imaginations and something that's always captured our interest as we made the decision to go to law school, as we made the decision to start this group too. So we wanted to do this forever. And it's particularly apropos that Tumblr, right after we made the announcement for this meetup, was acquired by Yahoo. And then before that, we had Instagram acquired by Facebook. And YouTube, of course, acquired by Google. So all kinds of these major acquisitions, all of which seem to demonstrate the fact that these communities of users offering up all this content clearly have value, and that value is just increasing as we go along. So with that in mind, I'm going to just sort of introduce our panelists and ask each of them to talk a little bit about where they fit in this unique sphere of user-generated content, and hear a little bit about what they do on a daily basis. And we look forward to hearing from them. So right to my right, we have Chad Mumm from Vox Media, creative director, right?
Yes.
So let's tell us a little bit about what you do and how you relate to this.
Yes, so Vox Media is a digital publishing company, and we have 3 consumer-facing brands. The Verge, which is consumer tech. We cover this space very actively. We have SB Nation, which is our network of sports sites, 322 team-specific blogs, and national and regional coverage. And then we also have Polygon, which is our newest site, which is a video gaming, culture, and news journalism site. And the way that Vox Media works, we were started 2 years ago. SB Nation has been around for about 6 years. It started out, and how it's relevant to this conversation, as a grassroots network of sports blogs that literally started word of mouth. Like one person started another, and started another, and started another, and then that begat 322 and this big network. And the idea around our sports coverage is, the mainstream sports media is a machine. And in many ways, our fans and our fan commenters and the people who publish on our platform, they are outside of the mainstream, and that is like a badge of honor for them. And so the idea of user-generated content is kind of enmeshed in our history as a company. The Verge and Polygon are very much journalistic endeavors we started where we hire the best journalists, and it's less grassroots. But we also have a big presence on YouTube, with YouTube in sports and contributors, and we publish all of our content across all of our brands. We're very heavy in video, and so we're always working with YouTube. We're YouTube creators, and obviously there's, especially in sports, there's tons of rights, things that come up all the time. So it's a very exciting time, for sure.
Definitely. And then to Chad's right, we have Sabria, CEO and co-founder of Olapic, which is a company right here at Projective Space, Lower East Side. So we're thankful to them for hosting us, and thankful to Pal for being here. Tell us a little bit about Olapic.
Thank you. Hello.
Yeah.
So Olapic is basically a photo platform for companies. So we help companies crowdsource user-generated content, visual content, mainly photos. So I think it's interesting that you mentioned before the hashtag and how he was submitting a photo, because that's exactly what we do. So we have what I would say a non-traditional way of submitting content. So no check boxes, no things like that, and we use it, or we help, let's say we help users submit content to their brand in easier ways than the traditional kind of upload button, browse, and then so on and so forth, register, things like that. So we facilitate the visual communication between brands and their audiences.
Great. And then to Pao's right, we have Amanda Rykoff, who is a recovering lawyer. She's worked in content. You were in-house with MTV, I think.
You're stealing my story.
I'm sorry. Okay, fine. Tell us about it. She's currently a sportswriter too, and columnist. So.
Thank you. I'm delighted to be here. Yes, as he's saying, it's actually funny. I'm sitting in the middle here because not only to break up, as we were joking, kind of the group of guys, but I feel like it's appropriate that I'm sitting in the middle because I fall very squarely right in the sweet spot almost of what we're talking about tonight. I actually, as Warren just said, I'm a recovering lawyer. It's been 5 years since I last practiced law. I actually got a coin or some kind. Anyway, I was a practicing attorney for many, many years. I worked at a couple big firms. I did a lot of entertainment and advertising law. So as a result of that, I had a lot of experience dealing with consumer-facing promotions, lots of entertainment propositions. I represented content owners and content creators. So I was kind of protecting the rights of those. I was never a litigator, but I negotiated acquisitions and contracts and license agreements. So that was something that was just always in my blood as an attorney. I have since transitioned over the last several years from an attorney to a business person, also again working for a number of major media companies, including MTV and ESPN. And then from ESPN, ended up starting my own website where again, I was kind of dealing with being a content creator for the first time, being independent, but also being very mindful of this minefield that we're in, especially given that I do have a background as an attorney, that I was always much more, probably a little more mindful of the legal issues than other independent bloggers. And then I ended up back at ESPN as a writer. So it kind of became a little bit of a transition where, again, working for a major media company, but also creating my own content. Now I'm a freelance sports writer. I've been freelancing since the beginning of this year, and again, once again, kind of, I'm creating content, but also needing to be my own, I do my own legal clearance, I make my own judgment calls about what I can and can't do, I do have a couple outside friends that could step in if I needed actually true legal advice, but for the most part, I'm kind of right in that sweet spot again as someone who, I create content, but I also engage with it on a daily basis as a fan, as a writer, as a syndicator of content, all of these things, social media, uploading things to YouTube, putting things on Vine. I mean, all these new technologies that literally are, emerging on a daily basis, and how can I adapt those into my daily goings on, but also, and of course, how can I make money off of it? And that's always the other thing that we're going to be talking about. So, sorry, that's my story.
Great.
Now that's where you go.
And we have Amyt Eckstein right here from Moses the Singer.
Hi, can you hear me?
There was an on switch.
I thought it was.
Might be dead.
Now?
There we go.
All right. So, my name is Amyt Eckstein. I'm a technology attorney with Moses and Singer. My practice is a transactional practice. Also, I advise on IP issues. I guess if I characterize myself, I'm a technology, intellectual property, privacy, and cybersecurity attorney. So I deal with content owners, content creators, and users often, regulated and unregulated entities. The issues I deal with often for regulated entities are, excuse me, like a healthcare company or someone that's a covered entity under HIPAA has a consumer or patient-facing site. What kind of interface do you allow your folks that are online actually to submit? It's a question of intentionally creating records versus unintentionally creating records. And in the regulated space, in the banking, privacy, and insurance business, privacy is a big issue, and you don't want to unintentionally create a record. So we look at that a lot. And then just, on a transactional basis, with user-generated content, I'm sure it's going to come up, what's the provenance of the data that we're getting, and if we entered into a transaction, can we really indemnify or rep to any of the rights we have or purport to have? And I think you see that with a lot of the websites now with Pinterest and whatnot. There's a lot of thorny legal issues that are going to become thornier as these sites kind of grow up and we see what's actually happening with them. So that's really it.
Great. And last but not least, we have Iliya Fridman from the Fridman Law Group.
Hi, we are a small firm, 3 attorneys, mostly representing digital advertising agencies, which are too small to have in-house counsel, so we're basically their outside general counsel. And as such, negotiate their agreements with huge brands for which they do social media campaigns, advertising campaigns online. And so on behalf of our clients, we have to analyze their potential exposure when they use UGC for these brand campaigns. And more often than not, we are basically the last resort, but try to push off on the liability in master services agreements onto the brand. That's not always possible. But because we are general counsel, we look at the issue of UGC sort of holistically, not just in terms of the rights to the content, but also what it means to use it online in relation to patent law, in relation to publicity rights, in relation to copyright, etc. It's crossroads of lots of different areas as well.
Great. So one question, since we sort of ended with the lawyers, I'd like to ask, can you tell us a little bit about the legal regime that currently is in place, some of the major statutes? Many people have probably heard of the DMCA here, the notice and takedown. They run into that on a daily basis, but what are, on top of that, what are some interesting legal topics that keep coming up for companies trying to make use of user-generated content and try to start these businesses, and also for the content creators who are in that position?
Well, just as a top-line overview, we look at the issue of user-generated content as basically consisting of three fields, I would say. There's the basic intellectual property law, and it's, you know, your general copyright, trademark, trade secrets. There is the issue of statutes, which you mentioned, you know, the Communication Decency Act, the Digital Millennium Copyright Act, safe harbor provisions. And then there is a matter of private contract, and that's the terms of use that you have to abide by when using social media networks, and in our case, the client agreements that we negotiate and divide the risk allocation in a certain way. Communication Decency Act is an old statute. It absolves internet service providers in the current context from liability for non-intellectual property claims that are caused by content suppliers. So the users that generate the content in our discussion. The DMCA, which was passed in the wake of, you know, Napster and Grokster cases, generally makes these internet service providers and web operators, website operators, liable for contributory copyright infringement caused by the content they enable to be posted. There is a safe harbor which shields them from that liability if they register with the Copyright Office in a particular way, and that's what's kept YouTube and Vimeo afloat, basically. They have registered and been found not guilty of contributory copyright infringement. The DMCA doesn't cover everything, just copyright claims, so we still have to worry about trademarks and publicity rights. So there are probably still areas where legislation has fallen short of addressing the potential risks.
So, actually, I would add to that, you know, HIPAA high tech could really come into play and often do. And also with DMCA, one of the interesting parts is the ISP has the safe harbor as long as they're actually not using the content. When they start to redistribute it, that shielding isn't there anymore, because now they're, you know, the idea was that they were, the AOLs of the world would just be passive conduits and they couldn't actually be the gatekeeper. And when you start taking the next step to exploiting the content that your users are actually posting, like Instagram, it'll be interesting to see Instagram actually post a photo that the person that uploaded the rights didn't have the right, to upload the image didn't have the rights to, and how that claim is going to work, because even if they were to, in theory, if they even follow the DMC notice, there wouldn't be that shielding because they're no longer the passive conduit. So that's an interesting wrinkle that we're going to start seeing. And I think Facebook has also faced that with whether likes and advertising next to likes has killed their DMCA protections, because they've now monetized through advertising the content. And so no one's brought the case yet, but there's kind of rumblings over whether DMCA really protects that kind of activity or not.
Absolutely. And to our more business side folks, the laws that we have in place, I mean, they're designed they're designed effectively to protect content creators. What are some of the extra legal devices, I guess, in place that you see that are in place to protect communities of people who are contributing content? And I mean, as content creators and also people who host communities, I would really like to get your perspective from both sides and people who make use of the content that's created from those communities. I would really like to get your perspective on how do you protect sort of the norms that I think we see coming up in these communities, and what's sort of the best practices for a business from that angle.
I don't necessarily have anything on that part of it in terms of best practice. I can tell you I have an example just from a week ago in terms of how the community itself can be the best enforcer of rights. I'm freelance, so my stuff appears on a variety of websites. I write for about 5 different websites right now that I have ongoing relationships with. Of course, I rep and warrant to everyone that I sign that agreement, that I have the rights to everything. So I make sure that I do. I even, I make sure I'm also very careful about photo credits, even those little things. But last week, I had an interview with Pedro Martinez, the obviously famous pitcher from the Boston Red Sox. And I was at an event where we actually had one-on-one access. It was an exclusive interview in the sense that there was no one else next to me while I sat next to him in the dugout at this event. And I asked him, I said, just, Pedro, it's been 9 years since the 2004 World Series and the Red Sox. That team is obviously, legendary, and it pains me as a Yankee fan, but it's been 9 years and I'm okay now. I said, can you tell me a story about that team that maybe we haven't heard before? That maybe now that we're 9 years removed, it can be told. And he looked at me, he said, oh yeah, for sure, the fact that we did shots of Mama Juana before every game during the 2004 ALCS. I, after did a double take, I don't know what Mama Juana is. It sounds like it could be something even more than it is. I said, okay, Pedro, can you tell me a little bit more about what this is? He said, oh, it's a Dominican rum. It's like almost a shorthand for what this is. I said, okay, can you tell me a little bit more about when exactly this took place? He said, yeah, it was before Game 4 of the 2004 ALCS, down 3-0. Down 3-0. And Ellis Burks, who wasn't even on the team but was on the roster, was kind of in the locker room and said, hey guys, let's shake things up. And he starts passing around this little cup. He said, he made very clear no one got drunk. It was little sips, but Kevin Millar jumps in and Johnny Damon jumps in. I'm sure Manny Ramirez was involved in some way. And I'm sitting here, I'm recording this whole thing, and I'm thinking, I've just struck gold, right? I mean, I've just hit. Every story we've heard about the 2004 Red Sox at this point has been told, except now we have a new one. So I immediately texted my editor, who's a friend of mine, and I said, I was doing this story for Sports on Earth, which is the new joint venture between USA Today and MLB.com, and I actually hadn't written for them yet. So this is my debut for them. Is I've got this scoop. I texted her. I said, I think I stumbled upon this story. Told her what happened. She's like, oh my God, can you get that to me? Basically by Monday morning. I said, absolutely. So it goes up on Monday. It blows up. I mean, it's all over Twitter. It's been picked up by tons and tons of sites. And I did a quick Google search. I did a quick, I was check on Twitter. Because that's my community. That's where I syndicate everything. And I see that there's a site that I don't know about that is basically, there's no attribution, there's no anything. And I look a little further. They've basically plagiarized my entire article. No link, no attribution, no anything. I guess you could say, oh, I've made it, I've been plagiarized. But I sent a note to my editor. I said, I'm not sure how to handle this. What do you think? Next thing I know, she's tweeted, oh, so this website has basically just completely ripped off Amanda Rykoff's story. The Twitter army, I have never seen. I mean, Twitter hates plagiarists. Everyone is calling out this website. Within an hour, we had an email, my editor had an email from the editor-in-chief of this website saying, we're so sorry, it was obviously an oversight. And they fixed it, they added links, so to me, that was the #1 example of how, even without, it was just the power of people recognizing this, there's ownership of content. This was a story that I had written, and at the very least, attribution should be, and I'm just, again, so from the community itself, just being Twitter, rising up against what they knew was wrong. And people that I didn't know. I mean, this was, at this point, we have like Amplitude, where, people start tweeting about it, and then their followers say, wait, what happened? And then they see what's happened, and then they get angry. And like I said, within an hour, it was fixed, and all was right. But I've never seen something happen that quickly in terms of rising up against, to protect someone's rights, which in my case was the rights to my story.
Crowdsourcing protection.
I think for us in our communities, our communities, it's a combination of what Amanda said. We have guidelines in place. So our network of sports blogs. We have we pay our contributors who write on the sites. We also have community members that are allowed to post blog posts that can then be featured in the main content. Well, obviously we have comments. We have a bunch of different ways for our communities and fans and commenters to actually post on the site. And some of them are in fact like privileged content but we do make it very clear, obviously, when people create accounts with us, we are very clear about our guidelines for infringing content. We aren't a major media company on the likes of ESPN, so we don't have rights for TV or broadcast, but we do pay for photo rights from Getty and from US Press Wire, and we make that content available to our users. So there's a lot of ways to tell the story that they're trying to tell using content that we have rights for. But we also just employ moderators, and it's somewhat self-policing, but it's also policed by our community. So if a piece of infringing content goes up, the moderators will see it, they'll flag it, and they'll give someone a warning. We own and design and control the platform that we publish on, so that gives us a lot of flexibility. And we actually have designed community moderation tools that allow us to flag users, to ban them, to give them temporary bans for a day and they can't post. And so we have this built-out system that we've developed to allow to how to kind of be punitive, but also encourage communication. What is a challenge for us, and is it interesting? I'd be interested in hearing the panel's kind of thoughts on this. Is places where there is no opportunity for self-moderation, and I think Content ID on YouTube is one that we run up against a lot. Where we definitely work with the leagues on establishing what our fair use rights are. And most of our content, because we don't do highlights, it is commentary driven. And we will take a play and describe what happened to it and how it shaped the context of the game from a really nerdy sports fan's perspective. But then we could do the same thing, and on YouTube, that content may get flagged automatically. And we'll go to the league and say, hey, guys, this is fair use. And they'll oh, okay, and they'll retract and stay up. But these automated policing is algorithmic decision making is a tough one as these things scale out, and you end up with platforms like Instagram and platforms like YouTube. YouTube's obviously the most robust at this point, and also the most likely for infringing content because of the ease of uploading video to it. But anyway, I'd be interested in hearing your guys' perspective on the kind of algorithmic policing of content.
Definitely. I think Content ID is something that we all, very much all have on our minds with this kind of panel and talking about new revenue streams. But I also want to get Al's perspective too, because you operate a service, where you're really looking to direct content to your customers in as quick and easy a way, as frictionless a way as possible. So can you talk a little bit about how you do that, and also whether that raises any potential issues with the content that you're getting and the people who created that?
Yeah. So what we do, just so you get a sense of, basically you buy something, you really like the brand, I don't know, you like Nike, and you take a picture of your new shoes or how you look on them, and then it will be awesome for you to be on Nike's page. And you decide, well, I may have made a much more informed purchasing decision if I had seen how these shoes would look like and not like a Photoshop version of it that I don't necessarily trust. And so what we facilitate is allow users that have bought products to actually take pictures of those and submit them to the brand's e-commerce stores and display them there so that not only they get quote unquote rewarded for being part of the brand, but also they are serving the community behind the brand that, or informing future purchases, right? And it's very similar to the text review model, just that it's more visual. And the only variant here is that for text reviews, you usually have to go to the site, you register, you click, you fill a text box, and then you submit, and then go through a moderation queue, and so on and so forth, and then if it gets approved, it goes live. What we found as a way of submitting, and I will touch back to your comment before about the channel and when, I mean, I think it's a great area. We basically use hashtags. From a submission perspective, if you think what Instagram does is basically it's allowing a user to publish visual content as fast as possible. And what does that mean for us? It means that it's not that you take a picture, then you have to download it to your computer, then you have to browse to the web page, you have to click browse, you have to look where the picture is, then submit it, and then register, and so on and so forth. But you actually put a hashtag, a very unique hashtag related to that product, and there's an implicit acknowledgement that you actually, I mean, if I use the hashtag Nike, obviously I might not be sending the picture, but if I say Nike, red shoes, reference, whatever, then the chances of me doing that by mistake are relatively low, right? And then that picture gets into moderation queue, and then the brand decides if they approve it or not. With our first 15 customers, we've collected about 1.8 million pictures, people submitting this way, which is easier than the traditional way. Of those, only 5% of those pictures have been approved by the brand, so there's a limited kind of exposure to the quality and the use of those pictures. And obviously they abide by all the rules on Instagram, Twitter, Facebook to reproduce that content digitally. We have a customer that wants to print a book with those pictures, and we said that they shouldn't do it. But I think that it goes to this fundamental definition of what is Instagram, right? At the end, we see Instagram as a channel. Why is not iPhone responsible? I mean, Apple responsible for having the camera that allowed you to take the picture in the first place? Or why is not, AT&T responsible for that? And at the end of the day, you wouldn't have it if you wouldn't be able to consume that content in the first place. So what's the use of the iPhone or the internet if you cannot consume content, right? So I think that the safe harbor could be applied to absolutely everyone unless it's extremely clear that there was like something like you, right? That we basically stole it. But if there's an implicit action that you actually submit that content, as long as you abide by the rules and you don't make it so that it's obviously, print a billboard or something like that, I think that you're good. And the reality is, and I used to tell this to Tarek, and I tell this to our lawyers, and is that we haven't, I guess that you hear this a lot, right? But we haven't gotten into any trouble. We haven't had any single end user complaining about, oh, my picture is on this website and I wasn't expecting it.
Right, so it all gets back to this really interesting idea of sort of consent with what you want done when you upload something, I guess. So you've never had anyone, I guess, who's ever come to you and said...
You can report and you can never, ever.
Okay. Can we talk a little bit about, I think there's something within Content ID, like Chad mentioned, that also gets this, which is within YouTube's Content ID system, there's an option potentially for a brand if they believe, if the Content ID system recognizes that you've uploaded pirated content in some way. The brand can issue a takedown through the Content ID system, or it can make the decision to put its own ads on top of that content. I would like to open up that question sort of generally, whether from a legal or a business perspective, to talk about, does that raise any any legal issues for YouTube potentially? Does that potentially get to the level of losing their safe harbor liability under the DMCA? And what are some of the conflicts that that's going to naturally create with your users, particularly when it's through this automated process that Chad mentioned? So any point on that I think would be fascinating.
I think that there's an interesting. I think at the end of it, I kind of think of everything in very simple terms. It's about customer benefits, right? And why is Pinterest still alive? And it's basically because they rely on millions of users that they are lying about whether or not they own the content that they are uploading. And that's what they are doing. And no one is really complaining because the benefits that they get out of it are huge compared to what they could potentially get out of a lawsuit. So I think that YouTube in a sense is very smart because they know that from a pragmatic point of view, if they offer a possibility to actually capitalize on that value in some way, and that kind of is more than what they could get otherwise, they will definitely, everyone is going to go for that route.
Can I offer one?
Please.
So I have one specific example that's not actually related to sports, but it's kind of fascinating in its own right. So we also publish a video gaming site, Polygon.com. And oftentimes, game developers will send out press releases for their new game, content that is a press release. Included in the press release, and their EPK will be a game trailer that is made available for publications to use, embed, take their, just like in the same way you would a press release. And those same game developers will oftentimes, maybe sometimes even accidentally and inadvertently flag and block that content on YouTube. And so as a publisher, we're taking content, our readers want to know about this new game, so we'll post it, and sometimes we'll just post it straight up, and that's all it needs. Sometimes we'll do commentary on it and then post it, but it's a press release, and yet they will flag themselves their own promotional materials appearing on the site. I think it's a really fascinating contradiction. And it kind of speaks to, I think, what the general problem of Content ID might be in that circumstance. I mean, it's one specific example, but it's kind of hilarious in a way.
I actually don't know enough about Content ID to be able to talk from a legal perspective or even a business perspective. What I can say from a consumer perspective, as someone who is very active on a number of user-generated content platforms, including Twitter, including Facebook, including Instagram, including Pinterest. I mean, anywhere where I assume, and at this point maybe I'm actually on almost the extreme end of the cynicism perspective, but I assume that if I take, if I use my iPhone, take a picture of whatever it might be, whether it's my shot from the subway platform after the Yankee game of Yankee Stadium at night, or whether it's a picture of my meatball parm sandwich that I post on my food porn Pinterest, I assume that someone out there is probably going to try to use it, and some brand might decide they want to use it and monetize against it, and I am SOL. And you know what? That's just how it works. I have the benefit of having a great tool to share this with my various audiences on different platforms, and I'm sure that when I signed up for whatever, I don't read the 75-page user agreement. I even as a former lawyer, I know I just click agree because I know I want my content on this platform. And that's why you said we're going to probably get there in a little bit, talk more about Instagram specifically in terms of that whole hullabaloo. Yeah. I watched it all unfold. Everyone is surprised that they're trying to monetize against our content for a free service. I might be on the extreme from the cynicism perspective, but that's how I pretty much assume. And if I assume that anything I put anywhere is going to be picked up by someone, again, other than a story I write that's going to be plagiarized. I assume if I post any photo of anything that I've done in my life, or post a Vine, that it could show up anywhere on someone else's site, and they're probably going to monetize against it. I posted a Vine, I'll just, about a little over a month ago, the night of the Boston Marathon bombing when they were captured in Boston. I was actually at Citi Field for the Nets against the Mets. Was actually Strasburg against Harvey, so it was obviously an amazing pitching matchup. It was a great fun game, and then they announced on the scoreboard, the Boston bomber's been captured. And of course, as every sports fan does in the United States, when something happens like that, a chant of USA breaks out, even if he's a US citizen, breaks out. And I, again, because my phone, the irony of this panel is that my phone is actually away, but normally my phone is attached to my hand, especially at a baseball game, and I immediately opened up Vine, grabbed 6 seconds of the chant, posted it on Vine. It's picked up by Deadspin, Big Lead Stew, and about 6 other sites within an hour. And then I get a tweet from SportsCenter later that night asking if they can use the video for their montage of the reaction within the sports world. Again, I don't get paid a dime for this. I get my name and my credit on SportsCenter for the weekend, and I get links and all kinds of, hey, that's really cool, but I have as much money, from a month ago from having posted that as I do today. So
what's interesting in a few of these things, there wasn't a copyright infringement there, probably, clearly, because it's just fans chanting.
Yeah.
But you're in breach of, unless you're in the media section, right? You were just an audience member. You're probably in breach of, just not that anyone's really going to enforce this, but you're in breach of the terms of use on your ticket stub. You're not allowed to film in the stadium unless you're media and given permission. So it's an interesting.
But I've also been credentialed, and I wouldn't have been able to do that from the press box either. In fact, you're better off in that case
as a citizen. Absolutely, because you're doing it on a non-commercial basis.
Exactly.
Absolutely. So it's an interesting thing, and I think a lot of these content IDs, the automated system that YouTube has, there's a real interesting fair use analysis with DMCA of exactly that. What if you're the same? Let's not use that example necessarily, but you're at the stadium and you're there with a family member, and you capture the game in the background, and you're just taking a video of your dad or whatever, a friend, and you post that on YouTube, and it gets flagged because it has the protected content. Is that really copyrighted content, or is it a breach of license, and should they be able to pull it for a breach of license and not for copyright reasons? Because they are pulling, essentially that to me is really a breach of a license, not copyright, and they should be able to pull it. So it's interesting. So I think that example where you have a ticket stub license and a similar example on, let's say, Pinterest or Craigslist now, where everything you post, you're saying you have the rights to, and you're giving them free rights to exploit. Instagram is the same way. Do you really have, if I'm going to sell a bicycle, do I have the rights to Schwinn or Trek image of the bicycle? I don't, and I didn't actually take a picture of my bike. I took a picture of, from the catalog of what it looked like 6 years ago, right? So I don't have rights to that image, and I uploaded it, and all of a sudden, Craigslist is saying I represent, or Pinterest is saying other people can use it, and if they sue me, if they sue a user, they're not going to collect anything. What does the indemnification mean? Are you really going to, this isn't use of a music license where they really need to make examples of people. So it's kind of like the terms of use are kind of hollow in that, but they're there.
There's a really interesting question, and I want to let Iliya talk on that too, but there's a question that's underlying the whole idea of content ID, which is the practical nature, how practical it is to actually enforce real rights that you have. And that's how content ID, at least as I understand it, came about, and it sort of spiraled into something about monetizing, whereas before it was just an easier way of pulling content down, according to the DMCA. And I guess this whole question of costs in actually enforcing your rights, whatever they may be, and how do we, the underlying the law is this belief, at least, that there is a good that you're protecting. How do we balance it to actually ensure that the good can be protected, I guess. Iliya, do you have anything on that?
Well, I think the content ID is smart, because any sort of lack of consent issue can be overridden by the granting of consent. And this is a way to alert the brands that they've been infringed, and for them to actually grant that consent to that infringement. And that resolves the issue, and the DMCA doesn't need to apply. And so, the problem you mentioned, kind of goes away. But what I found interesting is that technically your picture of a meatball sandwich and the article you wrote are the same thing. It's your creation. They should not be used by anyone else without your permission for a commercial purpose. I think what separates the two in your mind is that professionally you're a journalist, and so the article is valuable to you. You are not a food critic. You're a sportswriter. You're not a food critic, so your picture of the meatball sandwich is not commercially valuable to you. That's not the test for copyright. It's actually the test for trademarks. And what you've done kind of indirectly is suggest that we should apply this trademark-oriented test to copyright. Has the abuse of your personal image hurt you in any way? Has it taken away the market for that image? Because you're not in the business of selling audio recordings, so you didn't mind that the chant went around either. You're not in the business of selling food pictures, you didn't mind that went around. In your article, on the other hand, you didn't mind, but it's the same thing.
Well, I think it's interesting that you say that, because there's a lot of situations that I've contemplated that are too lengthy and to get into here, but there are a number of situations where I know that almost the instant nature of the technology that we have today, whether it's just posting a photo on Twitter or a Vine, is probably costing me, I'm not saying lots of money, but it is probably costing me some money. I've definitely posted some things just in a photo that have gone viral that maybe a few years ago, if Twitter wasn't quite, maybe 7 years ago, I take that same picture. I probably go home, upload it, write a blog post, or sell that story. And instead, I post it immediately without necessarily recognizing that it's going to blow up. Whether it's, again, the Vine or the people. By the way, I do take fantastic, as Chad knows, I take great food porn. Yeah, I am a noted food pornographer. So while I'm not paid for that, it is one of the reasons people do follow me. They really, and like I said, I have a Pinterest food porn board that's actually become very popular. But your point is very well taken. I think part of it is also the expectation, not so much me personally, but just, like I said, with the Instagram example. I know that if I'm putting it, I know that probably when I signed up for the terms and conditions, there was probably a line in there that said, and advertisers may use this, or third parties may use this. Again, for me, oftentimes, I just want to make sure I get the credit. I'm not necessarily looking for a license fee, and if I do run a Google search, or I notice that certain of my Flickr photos have been used by a third party and maybe they haven't done a proper credit, I'll contact them. But they're often not using it for commercial purposes. My sister-in-law actually found out that something she had actually posted was being used by a game site, they were making money off of it. And so she sent them a very nice note, and they said, okay, can we pay you $100? And she said, sure, and that was it. So I do think that there is that fine line in terms of what is that third party doing with it, as opposed to just sharing it, or are they looking to monetize against it. But you're right, and I'm not necessarily trying to take a trademark perspective to a copyright issue, because I own all of that and I know it is valuable. But I think I also, again, have that sort of cynical perspective of, I'd rather be the first, or I'd rather have a great picture of a meatball sub that's out there and people really enjoy, than not have that photo at all.
And even if that's the case, even if I'm a photographer that takes pictures of products, and I see that, someone on Pinterest is stealing my pictures and using them, and Pinterest in some way, eventually they will monetize it in some way. They don't now, but they will. And obviously the e-commerce company is benefiting from the additional referral traffic. Even if that's the case and I'm not getting compensated immediately for that extra exposure that was not agreed at the very beginning, even if that's the case, you always get a payback. So one of the things that we're seeing right now is a trend in e-commerce where basically the main design shifts from a really text-intensive e-commerce website structure into a more visual. And then suddenly the photographer is key to the design and then they get charged more. And so it's in their best interest actually that everyone pins so that their content becomes more relevant to the whole e-commerce experience. and so they can charge more. So eventually instead of going after the anonymous user that eventually pinned something illegally or whatever, lying, saying that it was their picture, it's actually making them a favor, doing them a favor.
So, but what happens when a user-generated content platform professionalizes itself? So if you think of the history of media online, blogging is kind of the first of self-publishing and user-generated content. Thanks to Google, that was easy to professionalize. People started making money on their blogs through AdWords and getting ads served from the content. The next step on that was YouTube, where it was for a long time just a haven for people to upload stuff, and their monetary value was measured in how many people commented on it and what many views they got. And then it professionalized, and Google started offering a rev share for partners. So all of a sudden, there's extra incentive for them to extract real value, and people create careers on YouTube. And it's obvious to see that Yahoo will have a similar approach with Tumblr, and they'll probably get a higher, if they're prettier, they'll probably get a more premium rate and probably give a bigger rev share than you could get from AdWords. So like, what happens when Pinterest professionalizes and all of a sudden your food porn Pinterest, you can actually make a real money on it, and it changes the dynamic a little bit. And I think that the protectiveness of your blogging content or your writing content, your professional journalism, it's been given a value by the platform of internet publishing. And same thing with our content on YouTube. We see the same thing. I guess one of the where these gray areas will happen is when those two come together. And I think like right now there's a little bit of a YouTube issue, and I'm sorry that YouTube is kind of the most relevant for me and coming back to it. But like right now there's some backlash against Nintendo for some Let's Play videos where professional YouTube game commenters have been recording video games and doing commentary as they play through it. They create careers based on that, and then all of a sudden YouTube has gone to Nintendo and say, hey, by the way, you guys can just start running your ads because this is your content. So they just turn the funnel on for them, and the system is built to favor the rights holders as it should. But I can imagine, and I don't have an answer for that, like whether that's right or wrong, because it is their content, with additional commentary on it. But I just think that like if we don't have an answer for that, or at least don't plan for it, every one of these popular platforms will professionalize if they want to keep incentivize their users to keep publishing. Especially ones that involve craft, like publicly writing and making videos and doing photography and doing vines or whatever else we do.
So just going off that, one thing I wanted to definitely ask all you guys about is, what do we do when a platform reaches sort of that critical mass where it has so many users, and in some cases more than there are, in many cases more than there are like people in countries. And effectively those terms of service that you're signing up for have the force of law and regulate a substantial degree of action that's very important to you as a user. Can we trust that the users in mass will be able to have enough force to ensure that their voice is heard and that their rights are respected to some degree? Or do we trust ultimately in the power of large corporations to respect their users' rights? And at what point, I guess, I think at what point does the government have to step in and actually start to decide the shape of user-generated content networks? It's a very sticky situation, and I think that's a very important question underlying a lot of this.
I think that many of these companies that you mentioned, they've been able to grow to these kind of huge sizes because they were very user-centric. And when you run a company, if you have to build a company based on that kind of culture of user centricity, it's very hard to change that when you are very, very, very large. And so it's like kind of shooting yourself in the foot. So I think that I wouldn't say that it cannot happen, but I would say that it's extremely hard to actually have a company that knows how they've grown and how they've built to become what they are, to actually suddenly change and do that. And that's why whenever they screw up, they rectify immediately, like Instagram, right? So, and I think, by the way, that was more than a misstep, it was a miscommunication. But I think that I don't think that you need actually to have some sort of government kind of stuff, like overlooking, making sure that happens. I think it's going to be, naturally it's going to happen by itself, otherwise these companies are going to disappear.
I would echo that very much. I think what draws people to these platforms is that sort of, again, whether it's user-centric, whatever it is, that I think I'll be very interested to see how Tumblr ends up with, now that it's owned by Yahoo, especially because I've been a Flickr user for years, and I know that they kind of sabotaged what could have been. I mean, they had Instagram, right? They had Instagram before Instagram was ever a glimmer in anyone's eye, and they just managed to turn it into an also-ran.
Now promised it.
They
did promise it.
They promised, so we're putting our faith in...
Just didn't see this.
Exactly. But I do think exactly what you're saying is right. I from a user, from someone who I know, I'm very loyal to almost to a fault, and if a place where I have decided to invest my time and energy in investing in as a member of a community, if they go against what it is that led me and probably many others to invest that same time and effort, then I'm going to find somewhere else where I can use that, and therefore it's no longer as valuable.
So I have a few different examples, I think, on point for that. Recently with Facebook, I think there was one of the Syria war beheading things where advertisers dropped because Facebook was allowing the content to continue. And so Facebook pulled content based on loss of advertising revenue from real advertisers, not just like AdWords or whatever. So that's self-regulating from people that are really helping pay the bills. I think Facebook is really, with Instagram and other, they face miscommunications and kind of growing up missteps. I think YouTube with Google went to a hate speech thing last year and heard about the mechanism YouTube has in place to address hate speech. They literally have hundreds of people sitting around looking at all the flag content, deciding what video is offensive from a hate speech perspective, and they're worldwide, and they're looking at local regimes and cultural sensibilities, and I don't know if they're geo-blocking all content, but I know they're doing it to some extent, and so that's really interesting when you start weighing First Amendment rights versus other stuff, and clearly they're not a government, but you said, are they? Not yet, that's right. But it's interesting that the terms of use of the platforms, this goes to a different idea that you mentioned, about laws and the government stepping in. Like Twitter, for instance, their trademark policy changes the trademark dynamic from being a likelihood of confusion to an intentional tort. So Twitter's rules say you can't register a handle to intentionally mislead, right? But that's not the trademark definition of what trademark infringement is. So you kind of have this interesting thing where if you represent a brand, a trademark owner of a particular brand, you can send a letter to Twitter saying, look, they're clearly in our space, violating our rights, tweeting about what we do, but they're not intentionally misleading based on your analysis. But if I sued you, you would be an infringer, they would be an infringer. And it's kind of this funny thing that it's kind of what you're saying with the DMCA. There is no DMCA equivalent right now in trademark, and it's I think someplace where it could expedite some of the disputes that are out there. And I think there was one more. I'll just leave it at that.
I just want to pick up on this hate speech being a locale by locale kind of analysis, and maybe it is the same for copyrights. What is the expectation of Americans for how their content is treated by corporations versus someone in Europe versus someone somewhere else? I would posit that a European posting a Facebook picture definitely does not expect and does not want it to be commercialized.
Or direct morale, they probably have a legal right.
And they do.
Yeah.
And but in the United States, you know, this is shifting to where it's okay. There is really no expectation of privacy, despite all the screaming about it in this country. And with social media networks, those privacy loopholes in the United States are entering intellectual property law.
I want to open it up to questions right now, actually, because we usually get some awesome questions, and I know Jolie is just desperate to ask something about Content ID. So, Jolie, please. Jolie also is filming tonight, just so you know, so if you ask a question, you may well be on YouTube, so.
Okay. I'll come and sit in the corner here. I may be wrong, but I think that this tonight came from a suggestion that I made
Definitely.
earlier, and this grew out of I shoot the Copyright Society of the USA's lunches, and they had Charlie Malhotra, who is in charge of partnerships at YouTube, plus the guy from the NMPA, who is the National Music Publishers Association. They were making lovey-dovey. They'd been at Dagger's Draw, but now everything is good because of Content ID and everything was wonderful. But I'm a user generator. I have 7.7 million views on YouTube, and now I shoot people with PowerPoints and lawyers doing, because that's punk rock today. But out of that, you know, I've had, you know, not very much of that has Content ID hits. You know, maybe, you know, 1% of that, and the rest of it doesn't. And I've dealt with this. So I had some problems just with going through the process of Content ID. When you get one of these, well, first there's no real due process like there is DMCA. You know, if you get a DMCA thing, you can challenge it and you can tell it, you know, make my day, take me to court, you know, and you don't have that as a response. But two, in their actual process, they don't tell you what you're supposed to be infringing. It just says some nebulous company has put a claim against you, and then you have a choice of, do you acknowledge it, deny it, or say you have permission.
Well, that's.
And you want to respond, Karen?
Yeah, sorry. Not to cut you off. That's actually, the Content ID is driven by the DMCA. So as I understand it, YouTube's, I mean, there's various reasons, but the way they set it up is they give like sports leagues the ability, or major content holders, the ability to go in and set up this process. And it sounds like maybe it's distributed more. I dealt with it about a year ago, and you actually set it up, and that way YouTube isn't the gatekeeper, and it goes really, the league, as an example, would set up the Content ID.
I will disagree with you. The Content ID is just simply a deal between YouTube and the content creators, where they have this process. Then if the process doesn't succeed, the content people can escalate it to the DMCA.
That's interesting. I haven't seen it. I've seen it on from the league perspective. I haven't seen the actual notices.
So, you know, that's my understanding of how it works. So, you know, so my first suggestion, which got applause from the assembled lawyers, was there should be a fourth option, which is, how much do I pay? You know, so that you as a user could license it, you know, rather than having the terrible ads or whatever else, you know, that you want on there. And then the other thing is this sort of, you know, I mean, I as a creator, you know, I like to put my stuff on YouTube because it has that option. I know that the licensing will get done, but for 99% of my content, there is no option to license. You know, I shoot small alt rock bands, and they don't have that opportunity to come in and be partners with YouTube. And I think there's an option here for one of Jonathan's students here, to set something up that's like a sort of TuneCore type activity, you know, which would take user-generated content, you know, and run a Content ID system that's kind of independent of Google, that would work for, you know, at the moment Google have the game because they're the only ones that actually run a system, outside of Google, you know, that would deal with which could do deals with all the content things and clear, so you could set it on any of these user-generated services going.
Like
That's
an
not the
ASCAP
case.
for...
Like, when I mentioned this, they said, well, they can always go to ASCAP or BMI, and I said, it's not, and I can't, as a video maker, I don't have that option of doing, if you're a music person, you have that option. We'd like to do a split. I mean, every band that I shoot down the cake shop or whatever would be very happy to do a 50-50 split with me on the content, unless we go through the process of uploading it to iTunes and licensing it for download. We can't just stick it on YouTube and collect from the advertising. There's no channel for us to do that, really. Okay, that's basically what it is.
Thoughts on that? There's a really lumped on top of that, it seems like the thing that stands in the way of some kind of collaboration, it's what we're talking about there, I think, is effectively collaboration between content creators within the platform. There should be some kind of way, it seems like there is an actual opportunity there, I would think, for a smart tech business to make those kinds of connections, I guess.
It seems like MySpace would want to do that. It has MySpace, it's still up, right? I haven't looked in a long time. But my understanding was MySpace became the de facto kind of music world way to exploit, and that's really where that kind of content went. I don't know how they monetize if they're in business.
I'd say what's more, it's a licensing issue.
Yeah,
more ways of licensing.
absolutely. And it's an interesting platform idea.
I think we're at a really interesting point with Content ID, and I think part of it is that YouTube has gotten much better at educating media companies on how to optimize and use the platform. They've made a really concerted effort over the last 2 years to bring the major media companies. It started with the record labels and the studios, but now media companies are being trained by Google, and so everybody's monetizing now. It used to be like, oh, just pull it down, and then they were like, holy shit, of course, let's just make money on it, so let's slap some ads on it. I've spoken to the guys at Univision, and they have one of the largest YouTube presences, but it's like all through Content ID. And it's because they just let everybody upload anything they want, and they'll flag it, and they run some ads against it. And right now, they're like, whatever, because they're not making much money on it, because it's hard to monetize user-generated content, even if it's through the Content ID system. It's just pennies. But everyone's going to start doing that. Nintendo's going to start doing that. As YouTube educates the content owners, they're going to stop blocking, which in many ways, like a block is a little easier to deal with, because it's just gone. And then you assess, and you say, where did I go wrong, or what's... But it's a little more nebulous when it's like, okay, like it's still up, but we're gonna start monetizing it, and like there's this weird, I think there's a real disconnect between this approval of like, okay, we're gonna grant you the rights to keep it on your account, but we're gonna monetize it. Like, who now owns the rights to that, or who owns the rights to that video? It kind of makes it a little nebulous, and I think as YouTube's preference shifts from blocking, and they train media companies just to run ads against it. Who owns that at that point?
And also, how do you verify that the person laying claim to it actually owns the rights down the line that they're...
Well, what happens when the guy who shoots the Russian meteor, that
Yeah.
clip gets on CNN, and then that CNN puts it online, and then they're monetizing it. They claim that clip with Wolf Blitzer, and then like this guy's just like, 6 million views is like, thousands of dollars overnight.
I think he should get paid.
Yeah, I mean, he owns the copyright to it, right?
It's the same with the Content ID where you have split copyright situations. I mean, I don't know if that's too sophisticated technologically. I doubt it. It's
Right,
probably
no.
just that it's rigged towards big brands right now.
Of course. I think this goes to that twin thing.
There's a case of the photographer AP took his picture off Twitter and said that was a public thing, and the court found against him, and he got paid.
Yeah, I mean, when you create, like the Meteor example, when you create when you actually film the video, I mean, under copyright, it's fixation. I think that's pretty much standard everywhere. But what becomes more interesting is when you take that and you upload it somewhere, that's where you're giving up your rights. When you put it on Pinterest, you're saying to Pinterest, look, I want everyone to play with this image. I'm granting you my rights in exchange for use of your platform. YouTube is the same thing. It becomes, I think, more troublesome when you don't know you're doing it. right? If you're doing it, let's say, in Gmail, and you email it to yourself with no intention of exploiting it, and then Google could look into your email, which they don't do, I'm just saying as an example. But if you do it eyes open in Pinterest or some other platform for the purpose of getting notoriety, that's your deal. That's what you've decided to do. You had the option not to exploit it, not to be the first person with the chant, let's say, and then take the chance that someone would scoop you and never get paid. So I think the trade-off is use the platform for free and give up rights, so it's not free, there's the trade-off, or don't use the platform. And I use Gmail because I love the service, and I don't mind seeing the targeted ads that creep me out all the time, right? So,
Well, I don't think that's the same for Facebook or Instagram currently, right?
no, Facebook and Instagram, they have the right to use everything you post for any purpose.
Not Instagram.
They scaled
so.
that back.
Instagram.
Did they scale it back?
Not durable goods on Instagram.
No, they don't have the rights to. So you give them. So you keep the ownership rights,
Right.
and they can distribute them, but Instagram doesn't own. So
No.
they define themselves as a channel,
Well,
not.
None of these platforms are going to take ownership over your content, because that's going to be that's not going to be held enforceable likely. But a license is as good as.
They get a non-exclusive royalty-free license.
Right, and well, it's interesting. Craigslist gets more than that, I think. So it's interesting to look at the actual license rights you're granting, and if you can.
And I think it's different.
I think that Instagram is not like that. Facebook, I agree with Facebook, but not Instagram.
It's not the case that if you want to have a website that's global, the only way to do that legally is to have that clause. I think that's the primary reason behind it. Is that correct?
No, the reason is I think to take your image and then to exploit it commercially, to run ads and all that kind of stuff next to it, right? So they can take it out of the context of your profile and then do something else with it.
So I read that if it's meant to be international, where you can operate in any country, then the only way the lawyers could come up with like making that work was to put this clause in place. Do you know about that?
That's where a private says worldwide, like the license set is,
Yeah.
I don't know, but my comment that I wanted to make before was mainly I think that the problem is with economic incentives is that if you wouldn't have Facebook or you wouldn't have Twitter or you wouldn't have Instagram if you had economic incentives in the first place. If you as a user, as an end user, knew that you have a remote chance of actually monetizing a content in some way because you hit the jackpot because you were, I don't know, next to a plane that landed on the Hudson or whatever, you would just be filling Instagram with crap all the time. I would be shooting all the time.
As opposed to now?
It would be worse. It would be worse. It would be worse because you would, people that have nothing to do, that would just like take shots of stuff just because it might get picked up and might get monetized, even if it's pennies. And so whenever, if you talk, for instance, when content creation becomes so easy, the challenge is that if you keep putting economic incentives, the whole incentive structure and the quality gets fucked up. And then that's if you talk to people on Huffington Post, for instance, they had when you put these economic incentives in some communities just don't work because you get lots of people that generate useless content just for the pennies that you might be able to generate.
We got just going to try and get, you had a question?
Yeah, this has been really an interesting discussion. I can speak louder.
Well, it's just not recorded.
Going back to your thought about cost benefits and incentives, based on this discussion and just doing more thinking about these issues, it feels to me that we've got a set of two kind of free options. One, a free option in the hands of the user who generates the content. Like you want to post your picture of the meatball sandwich. You want to get a following of other people who like food porn. And your free option is, hey, you get to keep doing that, but if at some point it becomes valuable, then you can start your own distribution platform and monetize it.
Yeah.
The free option on the other end, on the side of Google or YouTube or Facebook or Pinterest, is that they have a free option essentially in the end user agreement, and this is really cost benefit. They don't necessarily have to get into a shit fight over every little piece of copyright dispute or trademark dispute, but they have the option. If your meatball sandwich becomes so big that it becomes a meme and there's some iconography surrounding it, there's some sites that will claim, and actually as I'm a lawyer and I'm dealing with this right now with a client, they'll claim, well, during the course of our contractual relationship, you assign to us those rights. But they don't necessarily have to enforce those rights. And so for them, it's a free option.
My point was playing a little bit off of that, and I think it's just, again, I feel like this is a conversation. You're obviously, this is a conversation I have with my dad. Okay? No, I mean, I know this. My dad is, my dad is the kind of guy who sends me. He reads the New York Times and Wall Street Journal and the LA Times every morning. He sends me an email to say, great story on Derek Jeter in this morning's Wall Street Journal. No link, just tells me to look for it, and then I will find it. I mean, he learned to text. Great. I love my dad. Our conversations are amazing. I am very much who I am because of him. But when I'm visiting them, or they're here in New York, and we're at the restaurant, and the lamb shank comes out, and I say, I need permission to take out my phone and take a picture of this. And I say, what? He said, people want to know what you're eating. I said, no, it's not that they want to know what I'm eating so much as this is part of who I am. And he says, but are you paid? I mean, it's again, it's a conversation I have with my dad who's 77 years old. No, I'm not paid per se, but it adds to my value as this brand that I'm building, which is sports fan, sports writer, food pornographer, beer tourist. Sometimes it all combines, where I break a story about beer at Yankee Stadium on opening day and how they're actually not selling craft beer. If you heard that story, I broke that one too. And I say it's not about necessarily being paid in actual dollars right this second for this information. It's about becoming a trusted name or an authority in this space, or as with a following, and that following will lead to readers. It will lead to more sites that I'm writing for. It'll lead, that's part of it. That's the equity. That's the sweat equity that I'm putting in. Which, by the way, it takes me 30 seconds. And again, the Vine, all of that. Again, while I'm not actually monetizing right now against that, and yes, it would have been great for ESPN to have paid me a license fee to run that. People said, "Oh wow, that's really," they saw that. I would not have my Vine of that chant wouldn't have been seen by that many people if I hadn't been there with it and been first. I could not risk going home, uploading it to YouTube and posting it and then having it go into the abyss. So
I think we had one question over there. Yeah.
Hi. So, someone said earlier that Pinterest works because we basically all agree to look the other way over who owns what. And this got me thinking, this is sort of a double-edged question. For the lawyers, the question is, let's say, go in the Wayback Machine. The guy who creates Pinterest walks into your office, I got this great idea for a website. People can share pictures, and you go, great, so they're going to be uploaded. And you go, no, they'll rip them from other websites. And you being copyright and technology attorneys, what do you tell them? And for the content people, you have this great idea, and being somewhat aware of how copyright works, or aware that this may not quite be on the right side of legal, what's the calculus that goes inside to go forward anyway, or have your lawyer throw water all over it? So I'd love to hear those two perspectives.
I basically don't listen. So when you build a company, basically you have to decide what battles you want to fight, right? And there are risks, and there's copyright risk is one, or legal risk is one of the many risks that you have in building a company. And so you have to decide of all the percentage of my kind of brain power, how much am I going to dedicate to this, and what's the likelihood of that actually happening. And I think that as long as you are like, everyone has some moral standards, right? And so I'm from Spain, and in Spain we think that file sharing is legal, and that's why, you know, Mega Upload, the country that has the most users is Spain, and I think that it depends on how you see things, and as long as you abide by those, and the community of the service that you're like building stands behind those moral grounds, I think that you will be fine. In a sense, right now, imagine that you had, I don't know, Facebook gets in trouble because whatever, and some company really sues them, and Facebook says, I'm gonna shut down because of them. I think that you have like a huge crisis in this country. I mean, everyone starts like throwing rocks and
Well, that was Napster.
setting fires.
I mean, that was Napster, right? So we shut Napster down, and then you got iTunes, right? Somebody figured out how to monetize it in a legal way.
And you also got Paradise.
Right, no, absolutely.
I mean,
For a little while.
Napster,
It's still up?
Oh yeah,
Yeah.
you can't get rid of that.
yeah.
I guess a
It's
really
impossible.
good current example that would be Area, where someone said, "Let's just start this."
Yeah,
company
Area.
to
So-
accept."
Perfect example.
But
They had a
Ariel,
whole bucket load of money to pay for lawyers as part of the whole deal.
they set up their company by the book. I mean, I had nothing to do with the deal, but it's a brilliant copyright regime setup. I mean, it's, you know.
They
and-
found a little hole and drove a truck.
No, they
With the
well,
boatload of money
I don't know
back
if it was
to
a
the
hole.
lawyer.
I think they looked at the law and followed what the law said. You know, and I don't think that's wrong. I just think it's being savvy, right? If you came today and said, I'm going to make a website that's going to take every image on the internet, every news story on the internet, and catalog it and use it the way I want to use it, you know, would that be okay? And Google made a business out of it, right? And as did search. And when they were sued, it was considered transformative use. That was a judge's call. It could have gone the other way, except for the fact that the internet might have been shut down. So that was a policy decision, right? But I mean, linking is fundamental, and transformative use kind of to whether Pinterest is legal. You know, Pinterest is okay because there's DMCA protection and there's transformative use potentially.
And then on Pinterest, I always question what the value is, right? What is it that you're actually, when you pin, what is it that you're doing? And it's not like, obviously because of the legal contracts and everything, you're basically saying that you're submitting a picture and that you have the rights of that picture. But in a sense, what you're doing is actually pinning a piece of information. So you're saying this exists and it exists here. And that's the value, that's really the work that the person who has pinned has done. It's just that we don't have like how to categorize that as value. We don't have a way to describe that action, like that pinning. And so I think it relates a lot to that. So what is it that you actually, what's the value of your work as a user, and how that translates into a picture? And that's what makes the difference between like a sandwich picture or like an article. I mean, even though the medium, or like a really good like photographer picture, even though the medium is the same, it's fundamentally different. I mean, a picture for commenting something visually is not the same as a picture, even though it's a picture.
What if you're a food writer?
Well, that's actually Pinterest. Sorry, Pinterest has two different terms of use: commercial and non-commercial users. So if you register for a Pinterest account and you're a non-commercial user and you use it for commercial purposes, you revert to being a commercial user, and the difference really is indemnification. You, as a commercial user, you agree to indemnify Pinterest.
You know, it's interesting. One thing, I hesitated for a long time on joining Pinterest because I, again, as a former lawyer, you know, was worried about kind of that knowingly. I actually decided to treat Pinterest, I use it differently than others. Every photo that I upload is my own photo. I don't say, oh, I want that meatball sandwich that I took from Food and Wine. This is my own meatball sandwich that I consume. I like that the meatball sandwich has become a little meme for tonight. To answer your question, the last question about kind of, again, we don't have an in-house attorney for a media company here. I served in that role for a couple of different media companies, and I know, as you said, there's always that, legal's got to sign off, right? Or business affairs needs to sign off, and of course the lawyers or the business people were always viewed as, business affairs people were viewed as, we're the deal breakers, the red flags, the police, I always, my former clients, I hope anyone's listening, I always tried to at least be try to be a problem solver before you said no, right? Look at every aspect of it and say, okay, what's the idea here, and can we find, here are the issues that we're seeing, and we're probably seeing 4, 5, 6 different huge red flags, but maybe if we can bring it down to 3 red flags and then come up with new ways to approach what it is you're trying to do through those, again, I can't give specific examples, but that was always, at least that's something that I always tried to do in that role. Sometimes it just was not doable, the risk was too great. But if there was a way to do it with minimizing risk and still maintaining the concept or the goal of whatever that concept was supposed to accomplish, we worked with the creatives, with the brand people to come up with a way to do that if we could. And then sometimes even if we said, yes, let's raise it to, and then sometimes the highest levels of legal would then say no. So at our level, it's just, again, it's about risk assessment along the line and trying to be creative if you can, but every company's risk threshold is different, and every top decision maker has a different way of looking at it. I mean, Viacom, as you know, was like, they're, you have a glimpse of Jon Stewart in the corner, of your home video of your nephew, shut down, so it's.
I think we have time for at least one more question.
This is primarily for Amanda. So it seems whenever you're publishing your articles and your photos, you're accepting that it could be copied, it could be put anywhere on the web, but then under certain circumstances you want to be able to enforce attribution or enforce non-commercial, especially if it really explodes somewhere else. And this seems like a perfect match for licensing with Creative Commons. Have you considered that?
Oh yeah, I do that all the time. Yeah, I think I might have exaggerated, again, by providing that plagiarism example. At a certain point, it's always about just attribution and credit. That's, obviously if it's not a monetary deal, it's at least proper credit. And yeah, my Flickr photos are all available for Creative Commons non-commercial. But I'm pretty diligent. I have a Google alert on my own name. I Google myself to see where my name is popping up in places, and I will reach out. It's never a nasty gram. It's just a, hey, stumbled upon this. Can you add? And for the most part, when I have those kinds of exchanges, they always are apologetic and they fix it. The plagiarism was obviously a little extreme, but for the most part, yes, it's really about proper credit and attribution. And yes, I've done that. And but it's interesting too. We're talking sort of that fourth option of would you like to get paid? Yes, that would be a perfectly fine fourth option for me as well.
Maybe there's a way to brand each piece of content optionally with sort of red, yellow, green, or black, and each color signifies the different licensing regime. It's simple to attach, everyone recognizes.
It's actually like that with Creative Commons. They have a logo system, so you can, if you understand the logos, you can just look at the document and understand immediately what the licensing terms are.
So then it's a matter of
having the social media sites and the users buy into that, and the terms and conditions, instead of being arbitrarily this or that, provide these middle options. I like that a lot. And to answer your previous question, what I advise our clients is, whenever possible, try to get consent. And it's not just the users who generated the content, not just their consent. As we described, most of the time they licensed the content to the platform. Now you as a brand just have to go to the platform and get the platform's permission to reuse that content. Don't skip that step at least. That's, an email away, probably a small licensing fee, commercial use, but you're in the clear.
I just want to close with one quick question, I think, about, and it's not actually a quick question at all, but we're going to try to address it quickly, I guess. What happened with Instagram ultimately? We've all sort of beat around the bush with it, but was this, most of the people here I'm sure heard about the backlash to a proposed terms of service shortly after Instagram was acquired by Facebook. What was the end result of it? There was some debate as to whether there was actually any real substantial legal effect to those proposed second set of terms. There was a tremendous blowback. Instagram stepped back and went back to its old terms of service. What did we learn from it? Was it just the internet getting mad? Is there a reason for, does this strike the fear of God into particular platforms? Is there any lesson we can take out of it at all? Or was it just signifying nothing, I guess?
I guess I have the mic in my hand, so I'll start. I think the Facebook has had a few missteps like that, where they didn't communicate well or they didn't draft carefully enough. So I think probably at the most fundamental level it was a PR mistake. I think Tumblr and Yahoo should learn that lesson, and when they decide to monetize in some way the Tumblr and do something with that, they should be careful about how they roll it out. I think at the end of the day, it's a free service, and the value that kind of is, using it for free, and we want to monetize it somehow, and we want to do it through the terms of service like we're supposed to, and I think they just miscommunicate.
I agree. I think it was in large part a communication issue that I was viewing it more as a consumer. The snarky answer is what happened was everyone got mad at Instagram for about 2 weeks. Everyone jumped over to Flickr, and then everyone jumped back to Instagram. I feel like my Instagram community is just as active, and if not more so than ever. I do think part of it was Facebook. I think as much as we have such a love-hate relationship with Facebook, right? We can't live without it, but yet we hate it.
Just hate it.
You just I feel like I can't live without it, but I also sometimes hate it. And I do think that people probably overreacted to a certain extent because they said, oh my God, it's been bought by Facebook, and now Facebook is trying to take over the world, and they're trying to ruin my life by wanting to use my photos. So but I think, I look at things both as, again, as a former attorney, former business person, and a consumer. So much goes into good communication. So much of just being clear and upfront, and people will say, oh, okay. And that's all they needed. They needed that little reassurance, and then everyone just came back saying, we're sorry we got angry, we love you so much, we're back. And Flickr, I got a ton of new contact requests on Flickr during that 2-week period. Oh, it was hilarious. My inbox was blowing up with everyone I knew from Twitter. It was like, oh, hi Flickr. Haven't seen them on Flickr since. I see them on Instagram. So I do think it was a lot of everyone got angry, and I do think there are lessons to be learned from it. I don't know if the impact on Instagram was so much like a lasting legacy, but I do think that Tumblr, Yahoo can learn from it, and platforms going forward, because it's going to happen. No one sets out to create this kind of community or this business without looking for a way to monetize. And again, that's where the business/cynic in me says, duh. They sold it for $1 billion.
So sweet.
Exactly. $1 billion. Where's that money coming from? It's going to come from somewhere. So they had to try to justify the monetization and the value, and that's how they chose to do it. And they screwed up. But no one is angry anymore.
I think that at least from a business perspective, one of the key learnings from that is that one of the things that you have to realize is that this was a company that when it was bought had 15 people, right? And had millions of users. And essentially, and I registered on the first day for Instagram. So essentially the service hadn't changed at all, besides adding new filters. So really, they hadn't tried modifying anything. So they just hit something like stroke goal on the first day, and they just ride the wave all the way up to the top. And then the first thing they tried, they pissed off some people. So what? It just happens that they did their first test when they were 100 million in size. And of course that some people get pissed, but some people get pissed with our product, just that we're not as large as them. So I think that they took it fairly well. I was at the Instagram offices on Friday, and they are aware of that. So we were having this type of discussion, and they said, well, you know, the monetization team, there's 4 people, right? So it's not that we can think about absolutely everything that can happen. We just try it. It's just that when you try it, that's like huge ripple effect. So it's okay. I think it's okay.
Yeah, I mean, I agree. It's kind of communications nightmare. I do think, like, in the spirit of this group, you know, the hacker ethos is to move fast and break things, and that becomes really interesting in the context of you know, sitting in a room with a bunch of attorneys. But that is how, you know, a lot of the internet, you know, the companies that have been successful, just the products that we take for granted, you know, they're created with that attitude, and it really is like pervasive amongst developers and programmers and people who think that way. And so I think that's the fun and exciting challenge for, you know, groups like this. And even like in Ario's case, like, they're kind of like legal hacking. I mean, it's definitely like I wouldn't even call it a loophole, because they did just follow the letter of the law. But like, that's creative. That's being creative, and it's creating
of case law.
Yeah, exactly.
Case law.
Legal hacking. So.
Right, absolutely.
And I
very well done.
It's like seriously, like it's like worthy of applause. It's hilarious to watch like CBS be like, we're gonna go to become a cable network now, like because of you, Barry Diller. It's very funny to me. Anyway. Awesome.
Iliya, any last point or?
Yeah.
I believe that hacking ethos is to not charge money for the information or data or content obtained through extra legal means. That's the hacking. What we're talking about here is the opposite. It's charging money for what's not yours. So that's I have no sympathy for these companies, I'm sorry. I'll be honest with you. And from the perspective of, you know, a hacking kind of perspective, I think in Instagram's case, it was a deliberate attempt to make for the new owner the money that potentially is there, but the terms and conditions were too confusing to enable. Because of what you're talking about, probably 15 people, 4 people in the commercial department, whatever. Those terms of service were written as if by non-lawyers. There were portions of them that contradicted each other. They tried to solve that. Maybe there's something in the nature of the service where it allows you to personalize the picture by applying a filter, and it kind of became a victim of its own success. By doing that, you kind of make it your own, to the extent where someone else announces that they're going to do something with it, you feel personally hurt. You know, and that may be the reason for the blowback that was larger than in other cases.
Great. Well, thank you to our panelists. Phil, do you have something? Are we going to present one? We're going to present very briefly. We're trying out something new. We want to, in addition to talking about these issues, we want to present some little thing where we can talk about building something as well. Thanks, Joel. And so Phil's going to present something on the effect of what we've been talking about to some degree, really, sort of a licensing language idea.
Hi, everyone. So yeah, as Warren said, the idea here is to really start the discussion and to also begin the discussion, or at least propose an idea for something that we would build out of each meetup. So for tonight,
I think a theme, whether intentional or not, was kind of differing interests. And panelists, you can feel free to stay. Oh, if you want to see, of course. But I think a theme for tonight is disparate interests between the platform and the user, right? So my idea, which I put onto our new projects page, which will be fully launched with our fully launched website, for tonight is the future UGC license, right? So there's this strange phenomenon that goes on with the standard UGC license, which I'll pull up right here.
What is the UGC license?
So standard TOS says basically, when you upload content to this platform, we can do whatever we want with it short of owning it. That's basically what it says. So what's weird about this is there's an odd tension between what the company wants to take, what they need to take, and what the user wants to give up in their content. And I think the tension basically can be described here, which is really hard to read, but on the left you have the rights companies need to make their model work. So you have the rights that they take that are basically the sky, as much as they can take as far as the law allows them. And on the right you have the rights end users want to give to companies, which is usually less than that. And at the intersection of that license, the ideal UGC license is something in the middle. So my idea essentially, and I should say that we invite other people to come up with issues that they think they could resolve out of what has been said tonight, and kind of ideas that can resolve those issues. But my idea essentially is to come up with a new license, which doesn't show up on here very well because due to resolution issues, but essentially the company says, this is what we want to do with your content, and the user says yes or no. And then that yes or no is hardwired into the permissions in the platform. So, for instance, the platform checks, and probably in most cases, checks every column on the left. They say, yeah, we are permitted to redistribute all this. We are permitted to distribute your content to others platforms to the extent those platforms are integrating with our API without paying you royalties or licensing fee. And they have this series of statements, and then on the right you have the user saying yes or no. And that's my basic idea. As opposed to doing this boilerplate language where we take the sky, we have some form of consent here. It's idealistic. It's crazy, it's not going to work, but it raises the question of whether maybe, possibly in the future, this could be the direction we go. All right, I'll take questions, I guess.
I think
I made this last night at 12 a.m.
This is very similar to a privacy regime, right? So this looks like a lot like how you would set your privacy settings. And that's great. I think the issue here, well, there are a few issues. One, companies when they're starting up don't really know what they're going to do yet.
Right.
So you're creating DRM at the very beginning, which is great.
Right.
I think you probably want to see a $sign. The more times you say, no company, you don't get the rights, I want to keep it, fine, all of a sudden this free service becomes fine, that's $1 more that you're going to pay. So it's free if you give us all the rights.
Right.
It scales up with a $sign that goes from 0 to whatever the number is. The more you kind of move left and right. Right? And then maybe you have something that makes sense to a user because that's the risk benefit and allows the company to grow.
Right. And I won't address the second half of that because I think there are administrative problems with, well, there are tons of administrative problems with this, but with setting a $sign to certain rights that you hand over, yeah, it's a huge problem, obviously. But what you said at first, which was, I'm blanking right now.
Looks like a privacy.
Looks like a privacy. I mean, that's the idea. So what if this were placed somewhere outside of the platform's TOS, for instance? So everyone is looking at this,
And whenever a platform comes up with an idea, oh, this is one additional right that we want to take from the users, they'll add it to this general list, and then we'll say yes or no. And if they don't abide by that list that's on some third-party host, then we get some of that internet mob ridiculing that Amanda was talking about earlier. I don't know.
I guess my only thing is, couldn't they avoid all of that ridicule in the first place by now even providing this sort of option? So I guess come down to sort of
So just take ownership?
What would the cost-benefit analysis if they know that they can get away with taking all those rights? People are still going to come back and come back and come back more. Why even give them the option to opt out of certain things when they already have or
Right, and I think the idea here is the platform can interact with this yes or no, how they choose. So they can either hardwire it to the permissions that they have on that platform, or they can just say, oh, if you say no to any of these, we're not letting you on our site.
So the lawyer kind of answer is, as long as you put, we have the right to change these terms upon posting at any time, and then you can opt out of the service, or we keep it.
Well, which goes back to what I said earlier. If we host it on a third-party page and it adds the rights as they come up or as people come up with them, maybe there's less of that. And this is partly inspired by something Dave said a few weeks back, which is that TOSs are inherently problematic and that you agree to them without doing anything.
Is that your attribution?
That is correct.
You assent? What do you mean? I guess, no, I don't want to. It's a different.
Well, you assent to some set of terms that's buried into some page that you probably can't find at your initial, Facebook's terms of use are extremely hard to find.
Without clicking I accept or anything else.
Precisely.
That, by the way, is just only in this country, as far as I know, that's allowed like that.
Well, there's various cases I don't know how long the discussion will get.
The enforceability of the click wrap licenses, I don't want to get into. Yeah. I think it's the wrong focus, for one. I think it's the wrong way to look at this whole issue, but that's just me. Sorry. All right, yeah.
This is really interesting, and I have a lot of thoughts, but rather than say that, I just want to say this sounds like a really good way to rethink, reconsidering the user-generated content license bargain in a way that's not a law review article. So,
Thank you.
I mean, that's one way to take it. This is a completely different way. I think this is a much more useful way to approach it.
Cool. Thank you.
I'll say that, if you had a third body which you manage your user-generated content, like I was suggesting earlier, that would be one solution to this. But two, I actually saw a very similar proposal just 2 days ago for a social media contract, and I'll post a link to the Meetup so that you can see it.
That'd be awesome.
And there is a thing from Berkman Institute in Boston that goes back a couple of years, which is, user relations management or whatever it is.
Thank you. Yeah.
Briefly, if the platform decides to set all the rights by default to granted to the platform, 90-some-odd% of the users are never going to go to that page to set it to anything less than granting all the rights, because that would require them reading the legal terms.
Right, and I think that's right. I think the other part of this is the platform can present this as they please. So this is the standard document, and they can make it a pop-up when you visit the site, or it's something buried somewhere, or it's something on some third-party site.
Not to get back into the assent thing, but if you don't populate it at all and force users to go through the exercise, that's your assent.
Or you do geolocation, and for a U.S. users, the default is I grant permission to use it however you like.
Right.
For an EU user, it's the other way.
Right. Well, yeah. So I should clarify that the two columns are there for a reason. So maybe the platform decides that it's not worth it for them to take all the rights, and that really, ideally, to avoid alienating their network, which is really the tightrope they're walking, they say, no, we don't take any rights unless you say we do. So I think there's a matter of choice in here. Just kind of built in.
Awesome discussion. You should all talk to Phil, right now, as we bring this to a close.
Don't talk to him.
Yeah. Thank you again to all our awesome panelists. It was great speaking with you, and thank you everyone for coming and your questions and hang out and finish up the rest of our beer. So let's finish up here and then head there. And thank you again to also to Projective Space hosting us. We love them.